Please be seated. We'll hear argument in case number 230244, TCEQ against Paxton.
Court, Mr. Wasdorf will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
May it please the court. The trial court and the Court of Appeals erred for two fundamental reasons in this case. First, TCEQ timely submitted a request for an Attorney General decision under the Texas Public Information Act. And second, even if not timely, the deliberative process privilege is a compelling reason to withhold the requested information in this case. Turning to the timeliness aspect, TCEQ's submission of a request for an Attorney General decision was timely for three reasons. First, the use of the phrase business days in the Texas Public Information Act does not include days in which the agency was closed for business. Second, TCEQ's request for clarification to Sierra Club reset the 10-day clock under 552.222B. And third, TCEQ's submission was entitled to the benefit of the mailbox rule contained in 552.308B. Now,
So you're characterizing it as a request for clarification rather than a request for narrowing?
I think it is both, Your Honor. It is both.
Is it both, or is it that it's so difficult to differentiate the two? Where's the line?
Well, I think that's part of the problem. The Sierra Club and the Attorney General's office in this case attempt to slice and dice this into two entirely separate categories of requests. And I don't think that the statute needs to be read that way. Nonetheless, the specific
Well, it says if it's unclear, you can clarify. If it's overbroad, you can ask that it be narrowed. Those do seem somewhat distinct in terms of, yeah, you know it's asking for a whole lot of stuff. Can you please narrow this down? Seems like a...
And the statute could be read that way, but I don't think it needs to in this particular instance, because I do think that this request is both. Because the request for clarification or for narrowing in this circumstance was, are you requesting confidential information?
And it seems like that's something that a layperson would not know the answer to. So why is that either a request for narrowing or clarification?
It's actually one of the most common requests that agencies make.
That doesn't mean it complies with the statute.
And, Your Honor, I think the situation is that many requestors will say that, no, we are not requesting confidential information, either up front or after a request for clarification or narrowing, because they do not want to delay the release of the records that they should be entitled to. They don't want to go through the briefing process to the Attorney Generals. They just want to get the records.
Well, the statute says a government body may not make an inquiry of a requester, and then it has certain exceptions. But it seems like it's strange to ask the requester a legal question. It doesn't seem like that's either a request for clarification or for narrowing. Clarification, what documents do you want? Narrowing, this is a whole lot of information. We can get it to you faster or with less cost if it's less stuff. But if what you're basically saying to them is, do you, a question that's sort of discouraging them from asking for too much stuff, A, that seems a little bit inconsistent with the purposes of the Public Information Act, and B, I'm not sure they know the answer, right? Because you're the one that's supposed to determine whether it's confidential, and then the Attorney General can review that.
And many times, I do not think it is a legal question. because I think it is a factual question. It may require a legal determination. In this particular instance, Sierra Club is a very sophisticated party. I think they would certainly
Okay,
know
but we
whether
have to
they
write a
are-
rule for everybody that's asking for this. So if Joe Smith sent in the same request and you said, do you want confidential information? Joe may not know what to do with that. He may have to go get a lawyer. That's not what this process was designed for.
I mean, I don't think that takes it out of a request for clarification or a request for narrowing. By asking the question of whether you are requesting confidential information or not, it is, by definition, a narrowing request. If you are not looking for confidential information, you are looking for less documents than if you were looking for confidential information.
But how is Joe supposed to know if he's looking for confidential information or not? He's looking for what he's told you he's looking for. And maybe it's confidential, maybe it's not. Maybe TCEQ says it's confidential and the Attorney General disagrees, and so it's not confidential. So it turns out all along you weren't looking for confidential information. So I don't understand what Joe is supposed to say.
I think he could come back and say, well, I don't know what confidential information is or what confidential information you have, in which case I think the agency would process the request as if he was seeking the broadest scope of information.
If we agree that the TCEQ did, for whatever reason, the TCEQ didn't miss a deadline, and we go to documents withheld based on the deliberative process privilege, is it the Commission's position that communications with third-party contractors outside the TCEQ are protected confidential information under the deliberative process privilege?
They could be in the right circumstance.
Are you taking the position in this case that the communications with an expert outside the TCEQ are confidential deliberative communications?
Yes, I think so, Your Honor, because
Was there something in the contract that he was evaluating things confidentially? Because ordinarily, communications with an outside party would not be thought to be part of the deliberative process. So we review all of your briefs and materials and even expert testimony and all kinds of things. And all of that is public information so that everybody understands what we're reviewing as we deliberate and resolve the case. And so I'm trying to understand how outside materials, communications with an outside person could fall within that and why they would in this case.
I think you look to the bare elements of the deliberative process privilege, which ask whether it is pre-decisional, whether it is deliberative, and whether it is regarding policy making. And I think that those communications in this circumstance would meet that definition.
So it would seem like the third party wouldn't have any restraint on sharing those materials with whomever. And that's kind of problematic, right? Because there are various stakeholders in connection with any TCEQ decision. And if some group of people that have interests before the TCEQ are privy to that information and others are not, you can see that's a problem, right?
I mean, I think that comes up in many of the privileges in attorney-client privilege, the deliberative process privilege, the legislative privilege. There are frequently situations where third parties other than the person that possesses the privilege, might hold information, but I don't think that in and of itself
in the attorney-client privilege, if you share it with somebody who's not covered by the privilege, it's waived.
Well, yes, but...
And so what I'm asking is does the same concept apply here?
I think it should, Your Honor, yes. Moving back to the timeline, I wanted to address it a little bit in reverse and address the mailbox rule question first, because I think it is helpful to know what the end point is when determining whether the days were met. And so the mailbox rule contained in 552.308B provides that an agency may basically place the Attorney General request for an Attorney General decision in the interagency mail, which is what occurred here. The Sierra Club challenges that TCEQ is entitled to the mailbox rule because there was no evidence presented to the Attorney General that it was placed in the interagency mail by the deadline. So a couple things in the record is that the request itself was dated July 17th, 2019. It specified in the body of the request that the 10th business day after the receipt of the request was July 17th. An affidavit of Edward Cumberland, the mail operations supervisor for TCEQ, was submitted with the motion for summary judgment, explaining that interagency mail is received in the mailroom or collected from each division's outgoing mailbox at the end of each day. And then there was the email transmittal to Sierra Club with the Attorney General's request for Attorney General decision. And that email was also sent on July 17th, 2019. Finally, the OAG has acknowledged in its brief at page 10 that TCEQ requested an AG decision on July 17th, and the Court of Appeals at page 7 of their opinion also came to the same conclusion. So if we are working from...
So a lot of those facts that you just gave us are things that were not in front of the OAG in the initial July 17, 2019 submission. And then I think that it was in September 30 of 2019 that TCEQ made the Open Records Division aware of those things. But is it your position that section 552.308 sub B says that the evidence doesn't have to be given evidence to OAG before it opines, but as long as it's in the summary judgment record, then the court evaluates timeliness on the basis of these affidavits and other things?
I believe that's how it should be interpreted, Your Honor. That statutory provision is silent on when the evidence needs to be presented or who it needs to be presented to. The Attorney General in the Public Information Handbook requests that the information be presented to it, but I think that's an extrajudicial interpretation. If the court is looking at the statutes when determining these issues, it just sees that is there evidence that that it was timely submitted.
Do I understand then that the consequence, because TCEQ didn't give these things to OAG until after OAG's opinion had been handed down, the courts, we don't get the benefit of the Open Records Division at OAG, their thoughts on whether the deliberative process privilege applied here. We don't get any of that, and now the courts have to kind of do it in the first instance because TCEQ didn't put any of the affidavits in, didn't mention that they had been closed on July 5th, and didn't mention the request for narrowing or clarification. So we're all just kind of deprived of OAG's expertise on that.
In this particular circumstances, yes, Your Honor. I mean, it's just the nature of how the statute works that here we are faced with determining the deliberative process privilege, or the courts are. I actually think the merits of the deliberative process issue are not before this court because the Court of Appeals made no determination on that, just on the compelling reason issue.
When was the timeliness issue first raised? In other words, when did someone say you were not timely in making a request?
I don't remember the specific date. It was immediately after the Attorney General's decision initially came out. A request for correction was made to the Open Records Division of the Attorney General's office pointing out this information.
And could I get TCEQ's position, although I know you're here, Mr. Wallstar, from OAG, your friend kind of on the other side, although they've confessed error, says that 552.301F says that there can't be any reconsideration, that the request for correction, that OAG couldn't have looked at that because 552.301F is a ban on reconsideration. Do you share that reading of the statute, or do you have a different reading of it?
I think the statute is more clear with respect to reconsideration of the applicability of the exceptions under the Public Information Act. Here, with respect to a technical clerical error in terms of failure to provide, I think there should be an opportunity to correct those issues, which, TCEQ was completely unaware of until it was informed when the Attorney General's decision came out. I think that is distinct from a situation where TCEQ was briefing the exceptions under the PIA.
And before your time expires, could I get you to hum a few bars about our Constitution's anti-retroactivity principle and whether the 2023 amendment to the definition of business day ought to apply here?
Yeah, so a couple things. Number one, the case law is pretty clear that in the context of a remedial or a procedural statute that retroactivity is acceptable. Here we've got a state law or a bill that included two sections, 13 and 14 of the bill, that expressly provided that they were prospective only. And so I think it indicates a legislative intent to permit the remaining sections of the bill to be retroactive. But I also think it does not matter here, because I think the correct reading of the statute and the OAG's interpretation is that it should have been read to include July 5th as a non-business day, even prior to the bill being passed. Number one, because a business day is ambiguous on its face. It was not defined in the statute. OAG's long interpretation is that a business day under the statute did not include days in which the agency was closed that were not state or federal holidays. And finally, that the statute was passed in response to the Court of Appeals opinion in this case, which I think indicates a legislative intent to correct the court's misapplication of the law. So regardless of whether retroactivity is an issue in this case, I think the answer is the same.
Thank you, counsel. Any further questions? All right, thank you, Mr. Wasdorf. We'll hear from the respondents.
May it please the court. Ms. Johnson and Mr. Christian will present argument for the respondents. Ms. Johnson will open with the first 8 minutes.
Good morning, and may it please the court. Today, I'm going to focus on the clarification issue and the deliberative process privilege issue. First, turning to the clarification issue, I want to start with a question that the court presented earlier. How is Joe supposed to know if they want confidential information? And I think that really goes to the heart of this case. Only TCEQ knows the exact information that it has, not Sierra Club, who is the requester. And because of that, the Sierra Club, TCEQ is in the same place that it was before it asked Sierra Club if it wanted confidential information, because TCEQ would still need to gather all of the documents that are relevant to present them to the Open Records Division, for the Open Records Division to actually determine if it was truly confidential information and that TCEQ needed to provide it or not.
So has ORD changed its position on this? Because I'm looking at your brief at summary judgment, and you say the Texas Supreme Court previously found that a clarification request must seek to clarify or narrow an unclear or overbroad request. TCEQ's email satisfied this rule because it attempted to narrow the request to include only non-confidential information in compliance with the standard established in the City of Dallas. So why did ORD change its position on that?
So I would say ORD agrees that it is a technical narrowing of the request because it is, the scope is smaller and the fact that confidential information would not be included. However, under the City of Dallas, because narrowing and clarifying a request only restarts the timeline when that request is unclear or overbroad, we don't have those facts here. And so it would not be the timeline would not be restarted to ask for an AG opinion. And so in this case, when TCQ asked the Sierra Club, do you want confidential information? The Sierra Club didn't just say, yes, we want confidential information. It said that we want the information that is public, that should be disclosed under the Public Information Act, whether or not TCQ believes that to be confidential information. So
And presumably that's what every requester wants, right, is whatever they're entitled to under the Act.
Exactly. And because of that, TCQ did not learn any new information. Their question was not a clarifying question.
Is it true that the friend of yours on the other side says that there are frequent requests that start off with the notation that we're not asking for anything deemed confidential? Because really what they're trying to do is just get at things that are not even deemed that way, but they're public, they're hard to find on the internet. We just want to get it, and we want to get it fast. Is that false? Was that representation not accurate in your experience?
No, I believe that is true, that requesters do sometimes say they don't want confidential information. And I think what is really telling, if we look at the PIA, the Open Records Division is required to make a form for requesters under section 552.235 of the Texas Government Code. And in that requester form, there's a section that asks, do you want confidential information? And the requester can check yes or no. And so that might help the governmental
What's the
body.
point of asking for that information if it's not going to put the agency in a different position?
Okay, so there are a couple answers to that question. First, it does help the governmental body know exactly what information may apply, but it still does not restart the timeline.
If you tell them in advance, I can see why it wouldn't, because you're getting that checklist up front. But if the person didn't give you the information that would have been put on a form up front, then that's new information that the government needs.
So it is new information that they may or may not want confidential information.
And if they don't, you just said that helps the government.
So the form is separate from just a requester asking, because if the requester asks, doesn't say anything about confidential information, and then the governmental body asks, do you want confidential information, then they still will have to collect all of that confidential information to give to the Open Records Division to make a determination. Whereas when the requester checks off on the form that we don't want confidential information, that they're giving the governmental body permission to make that decision.
Isn't that what TCQ was doing here? It sounds like ORD's own form acknowledges that there are going to be some requesters who want the information, they want it quicker and they want it narrower. And then there are others that want it a little slower and they want it broader. And so 552.222b says, if a large amount of information has been requested, the governmental body may discuss with the requester how the scope of request might be narrowed. And so it seems like that would have been new information. Not that TCQ was unclear that Sierra Club wanted broad and confidential, but said, let's discuss. Do you want to get it quicker and narrower? And so it seems to me like that's a narrowing request. And so what is it about City of Dallas that says that doesn't reset the clock? Do you read something into the word overbroad as we used it in that opinion, or what is it?
So the PIA itself, it allows for a governmental body to ask to narrow or clarify a request. And that's all it says. It doesn't say anything about resetting the clock. It doesn't say that it has to be overbroad or unclear. But the City of Dallas, this court interpreted that section to say that the Attorney General opinion, that timeline would only be restarted if the governmental body asked the requester to narrow or clarify an overbroad or unclear request. And that is just based on the case law, that restarting period. And so it's perfectly fine that TCQ asked, do you want confidential information? That happens all the time. But it does not restart the timeline, so it doesn't give them an extra day, essentially. Because
Well, if the new clock starts from when the request is clarified or narrowed, that sort of makes sense because you've got a new request. The request is different. It's been clarified or narrowed, and so you restart the clock. Here, there was no change in the request at all, and so might that be a reason why the clock doesn't restart?
Yes, I think that's very important to this case, the fact that, and the Third Court of Appeals finds this too, TCEQ knew what the Sierra Club wanted. By asking if they wanted confidential information, they still knew the documents that were relevant. And because of that, they didn't have a new request, essentially. So from the very first day they received their Sierra Club's request, they knew what documents were relevant.
But I want to go back to something you said about what happens with the information. So if they say, no, we don't want confidential information, I thought I heard you just say that does work, and then in response to a different question, that doesn't change what the TCEQ has to do. So maybe you can clarify that for me. If we say, if Joe says, I don't want confidential information, assuming he knows what that is or can determine if there is responsive confidential information, wouldn't TCEQ still have to turn over all the same documents to ORD, and then they're the ones that determine whether something's confidential?
Yes, so there are two different avenues. If a requester is just asking, I want X information, then whether or not they say yes to a question from the governmental body, whether they want confidential information or not, that governmental body would still need to gather all of the documents, send them to the Open Records Division, and the Open Records Division makes that decision on whether they are confidential information or not. But if the requester uses the form created by Open Records Division under the government code, then the requester may say up front, hey, I want this quickly. I don't need confidential information. And because of that, the governmental body in that particular case is allowed to just send out the other information, does not have to show the confidential
So
information.
TCEQ determines for itself without showing it to ORD, in that case, what's confidential?
Yes, because the requester is trying to get it faster, essentially. All right, I see my time is up.
Thank you. Any further questions?
Just one. Is your client still taking no position on the retroactivity point?
That is correct.
Okay.
Thank you.
Thank you, Ms. Johnson. Mr. Christian?
May it please the court, William Christian on behalf of the Sierra Club. This court should affirm the judgment below and require TCEQ to produce the requested information because TCEQ did not comply with the strict deadlines required to withhold information under the Act, particularly the failure to request a ruling within 10 business days. And they cannot show a compelling interest to withhold the information that would excuse their failure to comply with the deadlines of the Act. Nor has TCEQ shown that the deliberative process privilege even applies to the documents at issue. This request involves important public health information regarding a cancer risk value for ethylene oxide, a chemical used frequently in industrial uses. It is important that the public have this information, and there's no basis for TCEQ to withhold it. I first want to talk about the request for clarification that's been discussed before. In addition to the reasons that have been discussed, that it is not a request to narrow or to clarify, I think what I return to is the default rule, which is that there is a prohibition on making an inquiry of a requester, except for these limited reasons: overbreadth, clarification. There's nothing in there about inquiring of the requester whether they want to get information faster by avoiding the Attorney General's ruling process. That is something that the legislature would have to endorse by allowing that type of inquiry to be made. But here, there is no clarification to be made. The purpose of a clarification is to help the agency better understand what is being asked for, to locate the documents accurately, to be able to produce them. And here, by saying, do you want confidential information, that is not saying, we don't know what you're asking for. We know what you're asking for, but we think some of it is accepted under the Act. That is not seeking to accurately locate the documents. That was what the purpose of the request for clarification in this City of Dallas opinion, where this court first endorsed this judicial rule of allowing the clock to reset. It doesn't apply to this type of request. And there's a real danger in extending it to this type of request because, as I think has been suggested, you could ask this of just about any single requester. Every single Public Information Act request, you can come back with, do you want confidential information? Clarify that. Do you want information that we think falls within one of the 150 plus exceptions of the Act? We need your clarification. And that stops the 10 business day clock until the requester responds, if they do so. And another point I want to make is that the statute requires any request for clarification or narrowing to include a statutory warning that the failure to respond essentially withdraws the request after a certain period of time. TCEQ did not include that warning in here. Another indication that this is not a request for clarification or narrowing under the statute, that it is something else, something outside what is allowed by Section 222.
If there was a situation in which something that you would agree was clearly a request for a clarification or a narrowing and it didn't include that, would it stop being a request for a clarification or a narrowing because it didn't include the statement of consequences?
I think that is certainly, yes, I think that it is not too much to ask the government agency to comply with the plain requirements of the statute. And if they fail to do so, they do not get the benefit of the resetting of the clock.
I can see them not getting the benefit of being able to enforce the consequences if they don't tell you what the consequences are, but it seems like it doesn't seem analytically linked to me to say that the lack of that statement changes the nature of whether it is a request for clarification or
Fair enough, fair enough. But I think it is one piece of evidence here that it was not a request for clarification, because if it were, you would assume that TCEQ would have followed the statute and included that warning request.
Had Sierra Club already answered the question by filling out the form?
No, Sierra Club's lawyer drafted her own request, and it's in the record, and it is very detailed and very precise. It does request, information that TCEQ felt was confidential, apparently.
So the form was never submitted. This request wasn't just attached to the form or something.
We did not check any boxes on a form. No.
Okay. So this was. This isn't a situation where you had already answered the question, where Sierra Club had already answered the question, do you want confidential information or not?
That's right.
I could see better agree with the argument that it was, not a clarification if you had already said, yes, I want it, and you were just, asked to regurgitate the same answer.
Right.
But you hadn't already specified something that OAG, for having crafted the form in the way that it did, concedes is is an important piece of information.
Well, I guess I go back to the Act, and the Act tries to make it very simple for requesters. You request public information, and then the duty is on the governmental body to produce it, or within 10 business days to go to the AG and seek exceptions or privileges or whatever. There is nothing in there that allows the governmental body to try and short-circuit that by trying to get the requester to agree to forego that process in exchange for some lesser amount of information. Again,
What about the second sentence in 552.222B? Would you agree that TCEQ's email of July 2nd, 2019 was not inquiring into the purpose for which information will be used? They weren't doing that, right?
They were not doing that, no.
Okay. And would you agree that a large amount of information has been requested, given that Sierra Club's request itself spanned like 3 pages? Very detailed, very clear, I think.
Yes, I think it could be seen as a large amount of information.
And so then why wasn't TCEQ's email discussing with the requester how the scope of a request might be narrowed? It would have been narrowed to the tune of like 6,414 pages of documents, right?
Well, we don't think those documents were privileged, so, that's part of the issue that Justice Udsby has gone. It's kind of at the eye of the beholder at this point.
And TCEQ was asking, as it sounds like the Open Records Division's form does, do you want to let us be the judge of that? And within minutes, Sierra Club said, no thanks.
That's right. That's right.
But it would have narrowed it, would it not?
It would have resulted in production of fewer documents to us, yes.
Assuming
But-
they were right about confidentiality.
Yes, and also the request itself didn't say, you've requested a voluminous amount of documents. Let's talk about how we can narrow it. It said, you've requested what we think is confidential information. Let's talk about how we can avoid going to the AG and having them resolve this and get you this information faster. It's a fundamentally different purpose.
When we're looking at giving somebody extra time to do something in the civil context, for example, if tolling of statute of limitations, as long as you get notice within the original limitations period, we don't typically extend the period because you still had a sufficient amount of time to act within the normal statute of limitations. Given that Sierra Club responded so quickly, why shouldn't that logic apply here? Because they still could have requested it within the 10 days.
Yeah, I think that's a good point. This is a judicially created rule, this tolling rule, and in this particular instance where within 5 minutes we said, no, give us what we asked for. It seems inconsistent with the purposes of the Act to extend the deadline another day.
Because there's really no dispute that TCEQ still had plenty of time to ask for an Attorney General opinion within the original time frame.
Yes, and one thing I want to point out is that TCEQ's 10-day burden was simply to say, AG, we wanted a decision and we're relying on the deliberative process privilege. They would have had an extra 5 business days to get the information together to submit and to explain why the deliberative process privilege applies. For whatever reason, they tried to do it in one submission, and they didn't do it timely in that case. But there's a 2-tiered deadline that provides a little extra time for a governmental agency such as TCEQ to get the documents together and explain to the AG why they're privileged, and also allows the agency to submit a representative sample, not necessarily all 6,400, but a representative sample. So
On the question of what's a business day, should the legislature's sort of clarification of what it wants a business day to mean inform our understanding of what business day meant all along under the statute?
Yeah, I think it can. I think the first question to ask is, is there a different outcome from applying the new law versus the old law? And we don't think there is. In other words, the Court of Appeals definition of business day was any day other than a weekend, a federal holiday, or a state holiday. The new statute defines business day, quote unquote business day, as exactly that. Now, what the new statute does is add on a wholly new procedure for designating non-business days. When an agency is closed, the executive director can designate up to 10 of those days as non-business days under the Act. That procedure didn't exist at the time, and certainly TCEQ has not ever designated July 5th, 2019 as a non-business day. It couldn't do so because the law wasn't there at the time. But it's strictly in terms of what's a business day, the legislature and the Court of Appeals are in exact agreement. So I think the new law does, in fact, confirm that the definition that the Court of Appeals adopted was the right one.
In the brief time that you have left, would you want to address the deliberative process privilege and why, in your view, it's inapplicable to your request?
Yes, Your Honor. There's several reasons. Many of them we've briefed under seal because they discuss the specific documents at issue. I heard TCEQ concede to you that communications with a third party shouldn't come within the scope of the privilege. I think the broadest...
No, I think they said, that it said that they should, but there could potentially be a waiver rule similar to the attorney-client privilege.
But two broad reasons I think apply. One is the third policy-making formulation element that this court adopted in the city of Garland. These documents, this cancer risk value is a mathematical derivation of a scientific figure, and this DSD is simply explaining how TCEQ got to this mathematical calculation. We don't think that falls within the policy formulation element of the test as this court framed it back in city of Garland. And second, the deliberative process privilege, one reason it can't be a compelling interest as well is it is a qualified privilege. It always depends on a balancing between the need for the government to withhold the information to protect frank discussions within the agency and the need of the person that's seeking the information to get it. Is it available from other sources? How important is this information? And we think the balance strongly favors Sierra Club in that instance. If you look at the record, I encourage, of course, you to look at the record. TCEQ's affidavit is less than 2 pages long. It has 1 paragraph about the application of the deliberative process privilege, filled with only conclusory statements of the elements. Nothing about explaining why the importance of applying this privilege in this case should justify withholding them. We put in a mountain of evidence, an affidavit from our requester, and including comments that we submitted that go through and explain exactly why this information is important to the public and why it should be produced.
Any further questions? Thank you, Mr. Christian. Mr. Wasdorf, I believe you have 5 minutes.
I wanted to address a couple things that were just raised. With respect to the request for clarification or narrowing, we shouldn't be nitpicking what is or is not a request for clarification or narrowing. It should just be, does that question request to clarify or narrow the public information request?
Well, that seems to suggest that kind of a bad or futile request for clarification would still work to reset the clock. And I guess the other side of that argument is, well, there could be endless such requests that were frivolous. And so what's your position about that?
Well, I don't think that's the case, because I think under the case law, it still has to be a good faith request. And I think it was in this circumstance. I also
So we don't have, there's nothing in the statute, am I right, that says that the clock resets? This is driven by judicial statements?
No, they're just not in the statute that actually authorizes you to make that request. There's
nothing that says this clock resets.
The 10-day clock. Yes.
Does the statute say that this clock resets, this 10-day clock resets?
Yes, that it starts from when you receive a response to the request for clarification or narrowing.
But that's because we said so in the City of Dallas case, right?
I actually don't recall off the top of my head.
If the statute says that as clearly as it sounds like you're arguing, I'd like to be directed to that. I'm not sure that it does, but it's a long statute, so.
Yes, Your Honor. I do want to raise the court to a risk that I think arises from this. If a request such as this, are you requesting confidential information or not? If that is not a request for clarification or narrowing, that means that the agencies cannot ask that question at all.
Well, they're asking it up front on the form,
Well,
and there doesn't seem to be a problem with that, because it just says you can't inquire of a requester, but you're not a requester until you make a request.
Yeah, but that's the Open Records Division of the Attorney General's
Right.
Office. I'm saying that as in this circumstance, if a requester does not use the form, does not check the box, then an agency is not going to be able to ask that question of a requestor.
That seems like a great argument for the legislature, that you should be able to ask that question. But I guess what I'm confused about is if you receive a response in 5 minutes that says, no, we want it, why do you need extra time?
I think you need extra time because the time that you spent in making the request for clarification and waiting for the response, however brief, you were in limbo. You did not know what the answer was going to be.
Well, that's not true. You could file or go ahead and file with the AG and then withdraw it if they said later, no, we don't want confidential information. You could proceed on the basis that they are asking for confidential information, or information that maybe you determine as confidential, which they don't know if it's confidential because they don't have the information.
Yes, you could, Your Honor, and that would be more work for the agency.
In that circumstance, suppose that that at TCEQ they knew that the agency's GC had a bunch of documents that would almost certainly be covered by the attorney-client privilege, and they're waiting to find out, do you want to go and have a fight about the attorney-client privilege exception or not? And until they find out, and then they're like, okay, well now we need to go get 1,000 documents from the GC or something like that.
I mean, that's the exact circumstance that I'm imagining, Your Honor.
If we're of the opinion that that you need the protection of the compelling reason provision, and the deliberative process is not always compelling, but it might be. Where does that, where do we go from here?
I mean, I think we can say that the analysis in the Paxton v. City of Dallas is the same for the attorney-client privilege as it is for the deliberative process privilege. The underlying idea, the underlying concept is the same, that you should be able to have free communications with your attorney, but likewise, you should be able to have free communications with the people helping you to make the decision. I mean, imagine for a moment the governor's office is having a debate over some policy, talks to the general counsel.
And if my question is, if we think sometimes that's a compelling reason and sometimes it isn't, and it depends on the circumstances, do we affirm and allow, and that'll be litigated later as to whether this was, in this particular circumstance, it was sufficiently compelling?
I think it would have to be, and as I stated earlier, I do not think that the merits of whether these documents were protected by the deliberative process privileges appropriately before the court, because the Court of Appeals did not address that.
I think your time has expired. Any further questions?
Just one question. Your friend in opposition said that TCQ hasn't done a designation within the meaning of the 2023 statute. Do you feel like that's something that TCQ can just like make it so now?
I don't know that they could retroactively make a day a non-business day under the statute. I would argue that the fact that they designated that day as an agency closed day, contemporaneous with it being closed, it would be sufficient under the statute.
Thank you, Mr. Wasdorf. Thank you. Thank you to all counsel. The case is submitted, and the court will take another brief recess.
All rise.